Beg to mention item number 14 of today's list.
14.
14. In this matter, my lord, some development has taken place, so I have to take some instruction, my lord. I have taken the consent of the other side. The matter will be taken up after 2 weeks, my lord.
Others are informed.
Yes, my lord, I have already.
Sri R. Islam Learned Counsel for the petitioner has submitted that there are certain developments for which further instructions are required to be taken by him. Development in the case, huh? Para? He accordingly prays for some time. Para? Matter is adjourned to be listed on the 19th, on 11th of February,
Much appreciated.
11/2.
Wait, please, Lord. My lord, item number 13, Lord, I have filed an, my lord, rejoinder. Today, my lord, my learned friend is appearing for the other side, my lord. So that has not come up on record, my lord. That is why, my lord.
When do you want?
My lord,
Today it may not be possible.
2 weeks, my lord, 3 weeks, any day.
Okay.
After 2 weeks.
Sri M.K. Das, Learned Counsel for the petitioner, has submitted that rejoinder affidavit has been filed today,
My lord.
which however is not tagged with the records. Para? Matter accordingly stands adjourned to be listed on 9th of February, along with the rejoinder. Is there any interim order?
My lord.
Interim order passed earlier to continue till the next day of listing.
Deeply obliged. Deeply obliged.
Sri M.K. Sharma, Learned Counsel for the IOC is present.
M. Sharma.
Huh?
M. Sharma.
M. Sharma.
I'm grateful.
Lordship, I beg to mention item number 23, your lordship.
Yes.
Some difficulty today, your lordship.
And PNB?
PNB,
Informed.
Mr. Ganguly is informed, your lordship, and I'm also informed of
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on till 10th of February,
Lordship.
10/2.
Lordship will say that not a single affidavit is filed by either of the parties, your lordship.
By the next time, pleadings may be exchanged.
Lordship.
Your Lordship, respondent number 5 is present on behalf of Mr. N.C. Das.
23.
23.
Oh. You are J. Busha.
J. Bush.
Ms. J. Busha, Learned Counsel representing, has appeared on instruction of Sri N.C. Das, Learned Senior Counsel for respondent number 5.
May I
Yeah.
please, your Lordship? Lordship, I beg to mention item number 5, Lordship.
5, yes?
5.
Yes.
The matter may be adjourned for 2 weeks, Lordship.
For the petitioner,
Petitioner.
Agriculture Department, Chaudhary?
Yes.
Okay. On a request made on behalf of the petitioners, matter is adjourned to be listed when? Listed on 30th of 30,
30.
31.
31 January, Lordship.
Yes.
Saturday, Lordship.
No, 31.
Thir-
30th of January. Friday.
Friday.
30.
Can it be taken on 29, Lordship?
29 motion matter, it will be difficult. And 28 to 8.
Much
Sorry,
obliged.
28 1.
Much obliged.
May I please, Lordship? My lord, I beg to mention item number 22, my lord.
Yes.
My lord, this matter may be taken after 2 weeks. I have gone through the record, my lord. The service is awaited. We have already taken steps.
We
my
have to
lord.
check. We have to check if it's for order.
As per office note dated 8/1.
I have to check the
I
order.
have filed my Wakalat number on behalf of respondent number 3 today.
Oh, yes. Okay.
You'd like to file some,
Then Lordship, can it be in the first week of February? I will obtain the updated instruction, Lordship.
22-0. We have to check the records. Record of subordination. We will take when the matter is reaches, not like this.
My lord.
Lordship.
My lord. May I please, your lordship? I beg to mention item number 12.
Yes.
I need some accommodation regarding the to obtain instruction from the petitioners regarding amendment of the pleadings. The 16 numbers of petitioners are there.
What kind of amendment are you seeking?
Because I have to add some party and strike out some party, and some petitioners are suffering from cancer after installation of the mobile tower. That's why
What is this cause of action?
installation of mobile tower defying the order of this honorable court. That's why I approached
Yeah,
this
it can either be a contempt or a PIL. How are it petitioned? If it's in defiance of an order, it can be a contempt. Think over. What is your name?
J. Deka.
On the prayer of Sri J. Deka, learned counsel for the petitioners. Matter is adjourned by 2 weeks to enable him to seek instructions. List on 11th of February. 11/2.
May I please, your lordship, I beg to mention item number 25 of supplementary.
Yes.
Lordship, here, as per order dated 12/12 of 2025,
Hmm.
I was supposed to take instruction and the DBC meeting, bid committee meeting will be held tentatively fixed on Wednesday. Lordship, may take it up next week, lordship.
Thursday we'll have? Okay. Re B.
20.
Chaudhary, learned standing counsel, the Agriculture Department has submitted that the meeting of the bid committee. Bid,
Departmental bid committee, lordship,
meeting of the departmental bid committee is scheduled on
coming Wednesday, lordship, it will be 21st.
21. And he accordingly prays for some accommodation. Para. In view of the above, matter is adjourned to be listed on 27th, Tuesday. Okay? Sri J.C. Gaur, learned counsel for the petitioner is present.
Lordship, let it be on 28th, lordship.
28, okay, 28,
Fine.
28 तारीख.
Lordship, I beg to mention item number 26 for
Hmm.
adjournment.
Hmm.
Due to some personal difficulties, Lordship. I have also taken the consent.
Here for the petitioner,
Yes, Lordship.
on a request made on behalf of the petitioner, matter is adjourned to be listed on 2nd of February,
Lordship,
2/2.
last of February,
Hmm?
fix, last of February,
Last week.
last week or mid.
Why, these are admission matters, don't say. Adjourned to be listed
After
on,
5, Lordship.
16th of February,
Lordship.
1/6.
Lordship. Lordship, I also have to mention item number 11.
Yes,
We have been newly engaged in this case,
for whom?
petitioner. We have also filed the wakalatnama today.
Hmm.
Matter may be fixed, Lordship, on 28 or 29 of February.
No, not so much time. It's a 2022 matter. We'll grant you some accommodation, but not that much.
Lordship.
What is your name?
S. Bolhuya.
S.
Bolhuya.
S. Borbhiya.
Yes,
Okay. Sri S. Borbhiya, learned counsel, has submitted that he and his colleagues have entered appearance newly on behalf of the petitioner, and accordingly prays for some accommodation. Para. Considering the prayer as well as the aspect that the matter is of the year 2022, accommodation is granted with a direction to list this matter on 4th of February, 4/2.
Lordship, interim is also there.
The interim order passed earlier to continue till the next date of listing.
Maso.
As I pay for listing of the matter, lordship, it was last listed on 5th March 25. There are
What is the stage?
stage for admission, lordship.
That means what is the urgency?
I think, lordship, the respondent is holding the charge of secretary, lordship.
Sorry, not urgent. Not out of turn listing. Yes.
Lordship,
My
next
lord,
week,
I beg to mention
in February
item
or
7.
No. Mention where is not the purpose of mention memo. Don't misuse mention memo. You approach the registry, file an application, it's up to the registry.
My lord, I beg to
Obliged.
mention item 7. This is regarding payment. I'm required to submit some paper
Hmm.
from the, get some paper from the administration regarding that list of payment bill.
Hmm.
Because my case is covered by Raizari.
You want time?
One time, 3 weeks at least.
You are SKing or SCing?
SC.
Sri S. Singh, learned counsel for the petitioner, has submitted that further instructions, including documents, are required to be obtained, for which he prays for time. Para. Finance department, anyone present? Finance, have you? Okay. Which earlier? 7. We're adjourning. Miss Udas, learned state counsel, and Sri H. Chalia, learned standing counsel, finance department are present, who do not oppose the said prayer. Para. Matter is accordingly adjourned to be listed on 4th of February. 4th February. 4/2 for motion.
My lordship, may I please, your lordship, mention for withdrawal on behalf of Mr. M. K. Sharma, WBC number
You
315620.
want a listing of this matter?
Withdrawal.
Withdrawal, then you have to get it listed, then one can withdraw. Is it listed today? So where is your mention memo? Okay. Yes, we can have it tomorrow or day after, whenever. Choose.
But in this matter, I was directed to get the instruction. And in fact, I have received my instruction, the verification is complete. And only because of there is lot of fund, the amount has not been released. And we have written to the government to release the fund, it will come from the government, then only we can release it, my lord.
But can that be a ground?
Well, because this is we have already written the letter to release the fund, my lord. Moment the
What did
fund-
you write?
My lord,
Mandor, who are parties here? Who are parties?
Commissioner James.
The direction was only to the commissioner.
Commissioner, 12 yes, Commissioner.
15
Who is,
was
who is free?
Hello?
Who is free?
3 is my lord Commissioner and division, 2 is division James.
Okay. Where is your letter, Mr. Bora?
my lord.
Date?
Date, my lord. One is 2/8/25 and other one is, my lord, 1/9/25.
You file your affidavit.
Well, sorry, 1/8/25. I'll file the affidavit.
Pursuant, heard 3, DP Mondal, learned counsel for the petitioner. Peruse the order dated 10/12/2025, pursuant to which Sri S. Bora, learned counsel, has entered appearance on behalf of the respondents. Respondent. Full stop. He has submitted that certain steps have been taken for release of the amount, and the government has been moved in this regard. Para, let notice be issued, returnable on on 16th of February 2020, not on 16th, basically whatever, on 23rd of February 2026, Sri Bora, the learned counsel, has already entered appearance for the sole respondent. By the next date, comma, the respondent is required to file the affidavit.
1, 2 and 3 are similar, my lord.
2 and 3.
The same order was passed.
Oblige, your lordship.
May I? This is my lord, non-payment of bills, my lord, an amount of rupees 2,98,150, my lord, due, my lord.
Where is the acknowledgement?
My lord, Annexure 4, my lord,
Page
page 19, my lord,
19.
19,
By whom?
by the executive engineer, my lord.
What is the requirement?
My lord, next page is, my lord, this is the,
What is the requirement of law in Tamsir? Acknowledgement by whom?
this should be, my lord, chief engineer, my lord.
We cannot digress from Tamsir. It's a full bench. You file additional affidavit. If you get a acknowledgement from the chief engineer, we entertain this writ petition. Otherwise, you have to go to civil court.
My lord, then, my lord, I will file, my lord. Some
Ah.
of the summer.
You are, what is your name?
K. Uddin, my lord.
Keuddin.
I want to collect.
Your name is not there, or it's there? Heard Sri Keuddin, learned counsel for the petitioner who has filed this writ petition for direction for release of contractual dues. Full stop. In this regard, he has placed reliance on a communication dated 10/11/2025 of admission of liabilities. Full stop. 3. R. Google, learned standing counsel, PhD, has however pointed out that the communication is not issued by the chief engineer, but by the executive engineer.
And there is no completion certificate also annexed in the writ petition.
He has also submitted that no completion certificate has been enclosed, full stop. 3. So the learned counsel, at this stage, the learned counsel for the petitioner prays for. Which is the requirement under the requirement of the principles laid down by the Honorable Full Bench in the case of Thompson Ali versus Swenson. 3. Would the learned counsel for the petitioner at this stage prays for and is granted 4 weeks time to take necessary instructions and file additional affidavit if so advised. List on 16th of February.
Item 6.
May please Lordship. It's non-payment of Lordship compensation amount to the petitioner.
Non-payment of
Compensation
compensation.
regarding acquisition of land. Notice
Revenue,
Hmm?
revenue department, I have to know. This is a thing this matter.
When was the land acquired, madam?
Lordship, there no knowledge about the acquisition of land of the petitioner's family, my lord. They are residing in Gwalior district, but land in the metro district, my lord. Then later part of COVID-19, my lord, period, they came to know that somebody has constructed over their plot of land. But thereafter they had represented before the concerned authorities, but no reply has come. And finally they searching about their land from and getting the Jamabandi. In Jamabandi, reflects that the land was mutated in the name of HPCL.
On the basis of what? What is the order in the
acquisition.
Jamabandi?
Lordship, they
Land acquisition.
land acquisition. And thereafter they have submitted a representation before the SPCL also. There is a letter, my lord. From that letter, they came to know that land was acquired. Acquisition was made under Land Acquisition Act. At page number 35.
Okay, we'll issue notice at this.
Lordship.
Heard Ms. P. Bora, learned counsel for the petitioner who is aggrieved by the acquisition of land done without any notice and without also paying any compensation. Full stop. It is projected that the land of the petitioner was found to be possessed by the HPCL, and on inquiries made, mutation in the name of the company was made on the strength of an acquisition proceeding, which the petitioner claims not being aware of. Let notice be issued, returnable on 20th of 20, huh? No, HPCL, is HPCL represented? No.
No, Lordship.
That will have not 28, we'll have it on 27th of February. You may, who's for Revenue Department?
Lordship, I appear for revenue department.
Okay. J. Hendrik, then Standing Council Revenue Department 1, then State District Commissioner, you will be taking. You does State Council for 2. Extra copies 3-4 by State Post UTD, steps within 2 working days.
Oblate.
Oblate.
Item 8.
May it please, Your Lordship. My lord, the present petition has been filed challenging the illegality committed by the railway authorities in imposing penal damage charges, my lord. My lord, in this matter, what has happened is we are the transport agent, handling and transport agent for the Food Corporation of India. And the railway has imposed the.
Your remedy lies in a writ court.
Yes, my lord.
Yes,
No, there is alternate remedy, my lord. There is one judgment, my lord, coordinate bench, my lord.
Yes, sir. There is one coordinating judgment, my lord, however, the facts are totally different.
But the same, my lord.
Principle should be same.
Yes, my lord. Last page, my lord, this last page 15, my lord.
That is what we are wondering. Why can't you approach the railway, the claim tribunal?
Yes, my lord, it is there, my lord.
My lord, herein, the question of locus is also there, my lord. Since it is, my lord, I am a handling and transport agent of the Food Corporation of India. Railway has imposed the penal damage charges upon the Food Corporation of India, and subsequently, according to the contract, the Food Corporation of India has deducted the said amount from me, my lord. That's why I am imposing, my lord. If in case it is an illegal charge,
You don't have a contract with the railways?
Yes,
no, my lord, I have the contract with the Food Corporation of India here.
Yes, Mr.
And similar nature, my lord, our honorable court has
Fact
issued.
is that the, because of
Now, can he
Because
approach
of-
the RCT? Can a third party approach the RCT?
that is,
Let us issue notice.
yes, ma'am.
We'll also consider Mr. Medhi's objection
Yes.
and we'll consider the respect at the
Because
appropriate
the
time.
issue is, my lord, so notice was not served, my lord. All these things, my lord, issued against railway, my lord. It will show, my lord, the same, my lord, principle, my lord.
No, but he does not have a
Yes,
contract
my
with the
lord, so
railways.
we have no contract with him, my lord. So.
So, no, so then how can he approach the railway claim tribunal?
Yeah, here it could also, my lord, it was from the FCA, Food Corporation of India, not from us, my lord.
No,
So,
the FCI is a party, you are also a party,
Yes.
not making you a party would be, the writ would be defective. You may not have a role, ultimately,
But-
let us see.
but.
Third, Sri D. Rathi, learned counsel for the petitioner who is aggrieved by levy of what penalty?
Penal
Damages
damage
charges.
charges.
Penal demerit charge
Yes, my lord.
amounting to rupees 91,39,200, which has arisen from an action by the railways taken upon the FCI, and consequently, the petitioner has been burdened with the same, has been saddled with the same. Let notice be issued, returnable on the same when on 23rd,
My lord, 25th.
25th,
My lord.
25th of February. Three, SK Methi Learned Standing Learned CGC accepts notice on behalf of respondents 1 and 2, who also raises an objection on the maintainability of the writ petition. Three, BK Singh, Learned Standing Council FCI, accepts notice on behalf of respondents 3 and 4. Let extra copies be served.
And deeply obliged.
Obliged, ma'am.
You can place this on the next occasion.
Yes.
Sadhguru. Item 9. Meera?
There, please, your lordship. Better request your lordship, if the allotment of 29 number of shop rooms in Algapur Bazaar under Algapur Gaon Panchayat. Regarding the your lordship, whether the shop rooms is to be allotted through tender process or not, same issue has been went up to the Supreme Court, your lordship, and petitioner not against it, your lordship. Ultimately, tender issued, your lordship, and bidders were also selected, your lordship, but that tender has been cancelled by subsequent resolution adopted by the Gaon Panchayat, your lordship. And accordingly, petitioner who were earlier running the shop, your lordship, they were allotted to continue, your lordship. But all of a sudden, your lordship, by issuance of notice, your lordship, in pursuance of a rate petition submitted by the successful bidder, your lordship, in which the petitioners were not even a party, your lordship, petitioner were asked to vacate the shop with, your lordship. Being a brief petitioner had.
You have to get yourself implicated in that writ petition.
But
How can be a writ petition against a writ petition?
no, in that rate petition, your lordship, petitioners are not even a.
You have to get yourself implemented.
But your lordship,
Can we pass an order in this petition when in a pending petition there are some orders? It would be contradictory. We can at best tag your petition along with that.
that-
Okay.
that's good.
Heard Sri K. Meera, learned counsel for the petitioners who are aggrieved by eviction notice dated 6/10/2025 regarding their shops in the Algapur
Algapur Gaon Panchayat.
Gaon Panchayat. The learned counsel has submitted that there has been there is a history of litigations with regard to the allotment of shops, and without issuing any notice, issuing any prior notice, the petitioners have been sought to be evicted. The Learned Council has, however, fairly submitted that such notice appears to have been issued in terms of an order passed in WPC 917 of 2025. Let notice be issued, returnable on who are the respondents? Private respondents are there.
Yes, Your Lordship.
On 23rd of February. Sri S. Dotto, Learned Standing Council, PNRD. For 1,
3, 5, and 6.
1, 3, 5, and 6. District Commissioner,
Two and
S.R.
four.
Barua, State Council for 2 and 3,
Two and
2 and 4.
Yes.
2 and 4. Extra copies. Steps for number 7, 8, 9, 10, 7 to 20. 7 to 20 will go. Be taken by speed post to steps within 2 days. List along with WPC 797 they go listen.
Returnable on lordship.
23rd. Any actions taken for eviction of the petitioners will be subject to further orders that may be passed.
Not so bad.
Yeah, I will listen after 9 months and Peter.
Yes.
May I please, Your Lordship? My lord, the petitioner is running a TMT factory producing the iron rods, Lordship. And Lordship, in 2014, Lordship, inspection was done and everything was found okay. Thereafter, again, thereafter the meter was burned.
Meter was
Burnt.
damaged.
Natural meter. And then after the meter was dismantled and assessment bill was submitted in 2014, Lordship. And against which, Lordship, we have preferred an appeal, Lordship, before the appellate authority. Ultimately, appellate authority found that the calculation done by the assessing authority is wrong. And I directed the assessing authority to reassess the bill, Lordship. Thereafter also, Lordship, the APDCL give a disconnection notice and against which the present petitioner have preferred a writ petition in this honorable court, and the honorable court directed to deposit the 50% of the amount, disputed amount, which we deposited accordingly, Lordship. Thereafter, we have, Lordship, the appeal was, writ petition was heard and it was disposed of, Lordship, on in 2025, 1870, 2025, it was 18/7, 2025.
Disposed of.
Disposed of, allowing my petition, Lordship. But in the last para, Lordship give a liberty to the respondent to file a review petition before the appellate authority, though there is no provision in the Electricity Act for providing any review, Lord. Even then, Lordship, when the appellate authority again took up the matter, only on the ground that the High Court has given liberty to approach the appellate authority. We filed our objection, Lordship. The respondent has filed a condonation petition because the Honorable High Court, while giving liberty to the respondent to file a review within 30 days from the date of judgment and order dated 18/7/25. But they had filed the review petition after 108 days, Lordship. They did not file, the respondent did not file any petition before the Honorable Court for the enlargement of the time, Lordship. And we took the plea that there is no provision in the for the review in the Electricity Act, so the appellate authority cannot review the order. But nothing was heard, Lordship, and without giving, we had appear on the first date, we prayed for adjournment, Lordship, because no copy, no annexures were furnished to us, Your Lordship, but the appellate authority passed the impugned order, Lordship.
On the first day?
No, on the third day. Sorry, second day, Lordship.
What is the impugned order?
Impugned order is that again directed the APDCL authority, Lordship, to reassess the bill. Accordingly, the bill has been reassessed, and Lordship, now they have given a notice for payment. Otherwise, disconnection. Today is the last date for disconnection, Lordship. 15 days time was given.
See, the earlier order 18/7/2025 had attained finality.
Yeah.
18/7/2025 order passed by this court in writ jurisdiction had attained finality. So you are making out a point that the statute does not provide for filing a review. But writ court has said and you have not challenged that. So
No, we have challenged. We
Where?
filed the writ appeal, which is pending for disposal.
oh, you have filed writ appeal.
Yes,
Oh.
and it is, the learned counsel has appeared in that matter, Lordship, and it is fixed on 6th of February for further order. I have
Mr.
accepted-
Sharma, you are appearing for PDCL.
My lord, may I just submit, my lord, first of all, I apologize, my lord, due to some medical emergency, I have
No,
to
no,
appear.
it doesn't matter. Tell us.
My lord, what has happened is here is, my lord, the first round of litigation that was passed, the learned single judge, after hearing both the side, and it was even though it has not been reflected in the order, it was a consented order in where lordship, because there has been a grave mistake done by the AERC authority, where the state exchanger would have.
Mr. Sharma, that would be difficult for us to accept, more so when a writ appeal has been preferred by them.
Yes, my lord.
Let us not go into that aspect whether it's a consent or let us proceed that it is a contested order, not a consent order.
My lord, even if that's so, till now the writ appeal has not been admitted. There has been a delay of condonation of petition has been lying. On the last occasion, on the last occasion we appeared in the condonation petition. We have
How
filed
much
our
is the delay?
148 days, my lord.
Your writ appeal is 148 days delayed.
Yes,
There
there is. And my lord, this writ appeal has been preferred after the order of the review.
But Mr. Sharma, the second question
Yes, my
is
lord.
that the subsequent order, the impugned order of directing reassessment
Yes.
was passed without giving them a proper opportunity.
Oh, my lord, my lord, if my lord may please, I would like to take to page number 57.
57.
Yes, my lord.
Yes, please.
May I
Yes.
read, my lord?
Yes, what is it?
The learned advocate representing Sri Sayaji Sport opposed condonation of delay as no sufficient cause was shown in the letter. He also requested a new date so that the senior advocate can represent on behalf of Sri Sayaji Sport. Considering a new date suitable, the board was fixed for the next date of hearing. The officer representing APDC was also directed.
Which page? 57, which
Yes.
part?
My lord, page 3, third paragraph, my lord.
The learned, yes.
Yes. May I read, my lord? I'm sorry, my lord, if I'm.
Yes, please.
The learned advocate representing Sri Sayaji Expert opposed condonation of delay as no sufficient cause was shown in the letter. He also requested for a new date of hearing so that a senior advocate can represent on behalf of Sri Sayaji Expert. Considering his request, a new date suitable for both the parties was fixed for the next hearing. The officer representing APDCL was also directed to submit an application showing detailed reasons of delay of submission of application for discussion and consideration on basis of merit. During next hearing, Sri Sayaj was represented by learned senior advocates Sanjay Kumar Kejriwal and Dheeraj Kumar Jaiswal and APDCL by Chinmay Jyoti Nath. In the meantime, AGM submitted an application for condonation delay date so and so. The APDCL has explained the delay. The APDCL authorities asserted the delay was neither intentional nor deliberate, but occasion due to bona fide. The learned senior advocate on behalf strongly opposed condonation. These authorities considered a rival submission. Then the next paragraph, my lord, next page. At B, my lord, hearing on review rectification application. At the outset of the hearing on the review rectification order dated 5/1/2016 by appellate authority, in appeal, it was clarified to both parties the review is not an appeal and appellate authority has no inherent power to review. The present jurisdiction flows solely from the liberty granted by the Honorable High Court, Guwahati. The scope of review is limited of any error apparent on the face of the judicial inconsistency, if any, in the appellate order dated so and so. It is further clarified that reappreciation of evidence, reassessment of facts,
or rehearing on merits is impermissible in review proceedings. Accordingly, submission of both parties were confined to limited scope of review. Submission on behalf of review petitioner submitted the inspection conducted in July 2014 conclusively established meter tampering which amount to theft within the meaning of Electricity Act 2003 and AERC Regulation 2004. It is contended that the original appellate authority order, next page, my lord, recorded a finding of malpractice tampering methodology directed for assessment was inconsistent with statutory provision governing the theft of the case. And then, my lord, the submission on behalf of the Sayaji Ispat is also been recorded. Then the consideration and the finding on review is at the same page, my lord, at bottom. This authority has carefully examined the original appellate order, the review petition, the objection filed by the consumer, and the judgment of the Honorable High Court, Guwahati, 18/7/2025. At the outset, it is clarified that the present proceedings are confined strictly to review rectification and do not amount to rehearing the appeal or reappreciation of evidence. Next page, page 60. The appellate order dated 5/1/2016 categorically record a finding of malpractice tampering. This finding has attained finality and is not under challenge in the present proceeding. However, despite such finding, the direction issued in the said order for preparation of assessment bill adopted method akin to cases
Mr.
of
Sharma, what had happened to the earlier amount, 50, what was the earlier amount?
earlier amount, my lord.
Earlier amount was lost, the first assessment was for rupees 1,59 lakh, out of which 50% we have deposited.
1 crore, may I submit if lord, as it was 1 crore 22 lakhs 45,949.
No, earlier amount was 1 crore 50 para 3 of the writ petition.
Out of that 50% you had deposited.
Yes.
We
And
have
now
deposited, then the assessment bill was prepared again, lordship, according to which we had to pay only rupees 27 lakh, which we had, which was adjusted along with amount.
Now the present demand is 72 lakhs.
72.
My lord, may I, if Lord allows, my lord, what had happened here, my lord? In the first round of litigation, there was an order by the AERC, and after that order was passed, there was an audit objection that came up. Under section 56(2) of the Indian Electricity Act, and as per the Learned Apex Court judgment, if there is an order where there is a gross illegality, the limitation under 56(2) does not apply. So we reissued them a bill. They had challenged that bill in 2017, and Learned Single Judge, after hearing both the after hearing our case, was of the view that because you have not that is why go for a rectification or a review before the ARC. My lord, the finding of it is at page.
No, today at the stage of motion, we are trying to balance something.
My lord.
We'll examine this, but there is a demand of 72 lakhs 45,000.
My lord.
Mr. Roy, what do you say?
50% will deposit.
And when is the rate appeal scheduled?
Lordship,
When is your rate appeal, the date in the rate appeal?
it is listed on 6th of February.
My
Okay,
lord,
we'll try to balance the equities till the returnable date.
my lord, only one ground before my lord. My lord, the learned senior here has submitted that we do not have the scope of review here, but that part has been dealt by the learned single judge while dealing with the previous case. That is, the clause is already there as per 2004 regulation. So, my lord, that
No, that we are not saying. That was the direction passed by writ court. So, not having the power of review, that we are not too much impressed by that submission. But the other aspects.
But on the prima facie, he has been heard in the review.
The other aspect, if there was direction by the writ court to prefer the review within 30 days.
Yes.
And you had preferred after 108 days.
Yes, my lord.
And the adjudicating authority has himself said that there is no question of Section 5 application.
My lord.
It's not a suit, it's not an application, it's not a judicial proceeding.
Lordship, there is no provision in the Electricity Act for condoning delay.
Those are matters.
That is a gray area, my lord. I understand.
Those are matters which require some determination. We are
My
not
lord.
saying you may be right, you may not be right.
My lord.
So today it may not be possible. Okay. Part 3, SP Royal Learned Counsel for the petitioners who are aggrieved by an order dated
31/12/2025.
31/12/2025 passed by the Appellate Authority, APDCL, and the consequential order of reassessment dated 5/1/2026. Full stop. The
My lord,
case,
it will be the appellate authority, APDCL, my lord.
yes, you have said Appellate Authority, APDCL.
My lord.
The case has a checkered history. Full stop. The petitioners had earlier approached this court with the grievance of a reassessment as well as a disconnection notice. Full stop. In the said writ petition, there was a direction for payment of 50% of the amount disputed, and the writ petition was ultimately disposed of on 18/7/2025, directing the petitioner, giving liberty to the petitioner.
Demand was quashed.
Was disposed of on 18/7/2025 by setting aside with the impugned action with a liberty to the petitioners to file a review before the appellate
To
authority.
the respondent. Liberty.
Liberty to the APDCL to file a review before the appellate authority within a period of 30 days. It is the case of the petitioners that there is no power of filing a review, and in any case, a writ appeal has been preferred against the order dated 18/7/2025 on this aspect. He has also submitted that the review was filed not within the prescribed period of 30 days, but after expiry of 108 days, and without there being any powers for condoning the delay, the impugned orders have been passed. Full stop. Para. Sri S.P. Sharma, learned Standing Counsel APDCL, who has appeared online, has, however, submitted that though a writ appeal has been said to be preferred against the order dated 18/7/2025, the said appeal has not been preferred within the prescribed period of limitation, and the same is still at the stage of condonation of delay. Full stop. Para. The points raised by the petitioners may require a determination. Para. In view of the above, let notice be issued returnable on 16th of February 2026. Mr. Sharma for?
My lord,
One, two.
except for respondent number 2, all the others.
For 1, 3, 4, 5, 6, 7, and 8 extra copies. That steps be taken for service of notice upon the respondent number 2 by Speedway State ADs. Steps within 2 working days. 3. Roy, the learned counsel for the petitioners, raised for an interim order. Full stop. The said prayer is, however, strenuously opposed by Sri Sharma, the learned standing counsel. Para, considering the facts and circumstances, and by balancing the equities, it is directed that the impugned orders dated 31/12/2025 and the consequent order and 5/1/2026 shall remain suspended, subject to payment of 50% of the reassessed amount, which is rupees. 72,
Yeah,
45.
45,
72,
949.
45, 959. The 50% of the aforesaid amount be deposited within a period of 30 days. 30 days will be the next date, before 30 days. Because we are making the next returnability on 16th. On or before 9th of February, or like 2025, 2026.
My lord, at page 63, the amount is reflected.
We have given the amount.
Much obliged, and I'm sorry. my lord, for that.
63, what we have given the amount, same amount we have said.
Yes,
Amount is the same, we have just dictated,
Yes.
isn't it?
Yes. Much obliged, my lord.
Mr. Ali.
But in this case, we are yet to receive instructions, Lord Chiefs. I traded the matter may fix on Thursday. We will get our instructions.
It is against what? Freezing of account.
Freezing of account.
You had earlier accepted notice
Lord Chiefs.
on behalf of Ganguly.
Lord Chiefs.
Okay, let him have the instructions. Part 3, R. Ali, learned counsel for the petitioner. Para. Sri K. Jain.
A. Dhanukal.
Oh, so K. Dhanukal, learned counsel. Appearing for the respondent bank on behalf of Sri Ganguly has submitted that pursuant to the order dated 28/11/2025 passed by this court, instructions have been obtained, have been sought for. Full stop. He accordingly prays for some accommodation. Para. List for motion on Friday.
Friday's holiday, my lord, on
Friday is holiday.
last
Okay, then Thursday, 22.
22.
Get instructions.
This is non-payment of bill, your lordship. The amount of this. No affidavit has been filed, your lordship. There is a similar matter. We listed on 6th. The lordship has already passed an order in that case that WBC 5985, that is to this matter, may be listed along with that on 6th too.
Where is the acknowledgement?
Your lordship, and can we? Page 17 is the representation, your lordship, and page 16 is the bill.
Acknowledgement.
There has no acknowledgement as such, your lordship, but
How do you entertain a writ petition?
Your lordship, they have admitted the fact that they have to pay that amount, your lordship.
In affidavit?
No, the representation is there, your lordship.
Your representation.
I have filed the representation and
Your representation, they have admitted.
there's
Where?
the bill, your lordship. The bill is there.
No, bail is not an admission. There has to be an acknowledgement.
I filed a representation, your lordship, and they have given their acknowledgement in the representation. True, your lordship. There is no acknowledgement as such with the.
What is the difference between acknowledgement in a
True, true. I
representation and
understand.
acknowledgement of
I
liability?
I understand.
So Deori,
There is
don't
no.
play with words.
No, your lordship.
You're too seasoned to play with
No,
words.
true, your lordship. I understand.
Don't cause, don't
True, your lordship.
invite.
I understand.
There is no acknowledgement.
Yes, sir.
Even if without acknowledgement, there is some admission on affidavit. There have been cases. But to entertain a writ petition, it will be against Tamshir Ali.
True, your lordship.
You file additional affidavit, try to bring some documents. Though this matter pertains to a claim for release of contractual dues, there is no acknowledgement by the concerned authority in the rank of the chief engineer
No, your lordship.
as required.
This is the police force, your lordship.
That is what, in the rank of
Oh,
chief
sorry.
engineer, as required, as laid down by the Honorable Full Bench in the case of Tamsar Ali versus so report and so. Para. Sri Deori, the Land Council prays for and is granted 3 weeks' time to file, to obtain necessary instructions and file additional pleadings, public documents. List on 13th of February.
May I please 6th of February, your lordship?
Can you do it before,
Along with the other cases, Your Lordship. I will file affidavit on both. the
on
cases.
on 6th of February?
Deputy, sir.
Item?
Extend Lordship. It is agreed by non-payment of contractual bill, Lordship.
We have filed our affidavit, my lord. In fact, we have admitted, my lord, more amount than he claimed, my lord. Lordship will find, my lord, page 235, my lord. Page 4, internal page 4 of my affidavit, my lord. 6 months time may be granted, my lord.
Hmm?
6 months time may be granted. That is my page 235.
No, we cannot say 6 months. We'll go by temporarily.
Lordship.
Heard.
A similar case, Lordship, has been disposed of in, I have annexed, Lordship. That Lordship will find at page 229, 228, 229 and 30, annexure 14.
But how can we adhere to this or go by this when temporarily is by a full bench?
Lordship, no. That's not concerned.
Heard 3A Ganguly, Learned Counsel for the petitioner, who is aggrieved by non-payment of contractual bills pertaining to hire of his vehicles. Full stop. As per the facts projected, the petitioner is the owner of certain vehicles bearing registration number, first order to file, 2410-2025. Number so the aforesaid vehicles were requisitioned by the respondent authorities, for which the petitioner had raised a bill of rupees 53,38,923. Full stop. As the bills were not paid, the petitioner had approached this court and notice was issued on 24/10/2025. Full stop. The respondent number 4 in this case has filed an affidavit on 8/1/2026. Full stop. Miss Udas, London State Council, has submitted that in the said affidavit, the claim of the petitioner has been accepted, and in fact, the amount has been stated to be a bit more than the amount claimed.
Page 235,
We have seen.
56, 27, 103.
Yes. As per the said affidavit, the amount has been stated to be rupees 56,27,103.
Yes.
103. First of for any reference, the relevant averments made in the affidavit are expected herein below, page 234, page para 6. Mute to lomba page para 6. The aspect of entertaining a writ petition for a claim for contractual bills has been clearly deliberated and guidelines have been laid down by the Honorable Full Bench in the case of Tamsir Ali versus so-and-so, reported so-and-so. In the instant case, the acknowledgement is on affidavit filed by the respondent number 4 as discussed above. In view of the above, the respondent authorities are directed to take appropriate action in terms of the guidelines of the Honorable Full Bench to clear the outstanding claim of the petitioner. in accordance with law. Bills are pending since when?
21,
Accordance with law?
23 to
Uh,
31
to
to 20.
take
23.
expeditious steps, sir. Report expeditious law. Okay. Restriction step disposal.
No period, Lordship.
Huh?
No period.
Period, we can say it chronologically. So that is why we don't want to cause prejudice to you. Your amount is blocked, so we said expeditiously.
Lordship. Obliged.
But taking chronology doesn't mean that you go year by year after year. You should take expeditious steps. That is not the,
Since 2023. it
that is
is
not the
pending, Lordship.
objective of Tamsir Ali.
24.
You
Petitioner is
make,
facing
make
huge
funds
financial-
available.
My lord, as per the.
If somebody has a bona fide claim, how does he run his business? Yes, next.
Obliged.
Mr. Mohan?
In terms of last order, direction was to being to the stand record by one appropriate, that was not filed, you know. Matter against the non-renewal of my arm license, you know, despite approach being made and the verification report submitted by the senior SSPO lordship.
Yes, what is it?
Yes, Lordship, the instruction is awaited.
Get the instructions.
Yes, otherwise
What
they
do you
have.
do, Mr. Mohan?
Lordship,
Other-
businessman and having the political background you have, lordship.
Political background. What kind of political background?
Lordship, petitioner was contested the last assembly election, your lordship.
Contested. Security forfeited.
That was forfeited and it was
Everyone can contest to get an arm license, get his security forfeit. Don't spend a single amount in your campaign.
no, that's it. There was a litigation.
And
was there.
it becomes a ground to have an arm.
There was political rivalry also there. He was physically attacked by the rivalry, your lordship, because they had injury, severe head injury was there.
Where is the FIR?
Lordship, FIR was there, so many FIR was there, lost by the present petitioner, and the report, inquiry report.
And FIR against you, how many?
It was already closed, your lordship.
Counter FIRs are also there.
No, that FIR, that counter FIR was not there. It is regarding other aspect, your lordship. That FIR has already been somewhere acquitted, one. It is prior to grant of my license and some already submitted final report, your lordship.
Have you ever used your license, utilized your license, used your arm?
No, lordship, it is after, no, it is prior to the issuance of the arm license, your lordship.
No, it is only for renewal.
Now, this is for renewal, your lordship.
Have you ever used your arm? No. Shown it. You must have shown it a number of times. You don't need any, no citizen will need any arm. It is for the law and order personnels. Why do you need arms?
But because the rivalry so far the affair is concerned.
There's something called law and order. Law and order will take care of you.
Is also withheld.
Why do you need an arm? Just take instructions.
Yes, otherwise they have challenged one communication, Lordship, by which the ADC has sought some detailed report from the SSP.
See, there are two
96,
aspects.
Lordship.
The first aspect is of a threat perception which has to be genuine. And second, even if there is a threat perception, why does he need an arm? He can be provided with a PSO at his cost.
That was subsequently because of the order passed, it was withdrawn, your lordship. Subsequently by the committee was withdrawn.
So then there is no threat perception.
Right, it was already been considered. There is a direction. If there is any threat perception will come, that will have to be considered by the authority. There was other.
Now, where is the averment that you are under threat? What is your age?
My age is 40.
What do you do for a living?
Lordship,
What do you do for a living?
lordship, having the business, your lordship.
What kind of business?
Lordship, different kind of business. is there.
Syndicate.
No, lordship, not syndicate.
Syndicate business with an arm. What business?
Lordship, business, he was the holding of the petrol pump, your lordship, and as well as the some water supply businesses also there.
Not impressed. Okay, you take instruction. Pursuant to the notice issued on 16/12/2025, comma, No, don't say like this. Notice was issued in this case on 16/12/2025. Court sub 3 S.R. Barua, London State Council has prayed for and is granted 4 weeks time to obtain necessary instructions. List on 16th of February. Get the instructions
Lordship.
on the basic proposition, whether there is a need. Okay, next.
18.
Yes, Mr. Mehdi.
I think the last package is also direction given for standing cost of health in familial department. Giving instruction.
Lordship, it is regarding non-payment of contractual bills, Lordship, and notice was not served because the Honorable Court directed me to get some, Lordship, I have missed the matter, Lordship, my name was not shown today.
Day after tomorrow?
Lordship, I'll, first week of February, Lordship, because.
No, you only need to get the name of the respondent 6, present
yes,
incumbent.
Lordship, on Friday, Lordship.
Friday is a holiday.
Oh, sorry, Lordship, Thursday.
Thursday.
Thursday,
Okay.
Lordship.
Thursday?
Lordship, similar matter also pending, your lordship, similar content matter, same content, same petition, lordship.
Lordship, but that matter has not been listed now in the contempt proceeding, some.
First, let him
Yes,
give
sir.
you the name of the respondent 6, present incumbent, then we'll see, okay? Sri H. Alia, Learned Council has prayed for some more time to obtain the instructions in terms of the order dated 18/12/2025. Para? List on Thursday.
Lordship.
Thursday date, huh? Thursday 22nd.
Yes, sir. This is content matter is for non-compliance of order.
Already order has been complied with, my lord. Verified, and my lord, I have filed the affidavit, my lord. Lordship, on
But direction of this honorable court was to verify the pending material bills, not to verify the spot verification, lordship.
it was, my lord, filling up of art and all, my lord.
And
So,
they have verified after 5 years of completion of the work, lordship.
uh,
After 5 years, but they were directed to verify the pending material bill only.
Lordship, this is Peru's last order of this honorable court, man.
Have you been paid any amount, Mr. Neo?
They have paid only 7 lakhs 58,000, lordship.
What was the direction of this court?
To verify the pending material bill, and if it is genuine, then I may be.
But on that aspect, there is a direction and observation that you have to approach the civil court.
Yes.
Lordship,
How do you
but
overcome
the
that?
amount was admitted. It is
Where?
revealed from their letters, lordship.
Page?
Our
Page
page 123, lordship.
1, 2, 3.
1 to 3 of our reply, lordship. This is the letter of the BDO, and this BDO have cleared all the pending material bill. They have pending my bill only because I have approached this honorable court. Otherwise, all pending material bill they have this respondent authorities has cleared. They themselves admitted by this letter, lordship. They have submitted their proposal, lordship. In our affidavit in reply, I have annexed.
How much is the amount which has been mentioned in 123?
123 is 25 lakhs 22,533 rupees.
Where do you
lordship.
get?
It's the six lane, lordship.
Oh. No, working estimate is rupees 25, then wage 10 lakhs, material so and so.
But due to some case, civil case pending against the plot of land, lordship, they have keep pending this bill, lordship. That is another matter, lordship. I have given work order. I have completed my work. That work has.
See, we are in the contempt jurisdiction. Where is the order of the court?
Order of the court is
Page?
in our contempt petition, lordship.
Yes.
Page 13 onwards, lordship. From para 5. It was only directed to verify the pending material bill, Lordship, not to verify the spot. And they have verified after 5 years, after passing of 5 rainy season, Lordship. There's the land was not bounded.
Okay, we'll hear this matter.
Yes, Lordship.
Affidavits
We have already filed,
have been exchanged
my lord.
and the matter can be taken up for final disposal. Tara, as agreed to by the parties, list on 10th of, not 10th, yes, 10th of February.
Lordship. They have submitted 5 bills, Lordship. Out of 5 bills, 4 have been cleared, but 5 number bill is still not cleared, Lordship.
My instruction today, even telephonic instruction that has been cleared because the Mrinal Das Malat petitioner is employee Malat. He is a government employee and he has been.
That time he was not
His
employed, Lordship.
Malat brother is Malat executing the work. So my BDO has already Malat categorically stated over telephone that we have made him understand the brother that the bill has already been cleared.
After
And
completion of this work, he have joined in the Assam Police, Lordship. After completion of the work, not at the time of his service period, Lordship.
he's
After
saying,
completion, he have got selected in the Assam Police. Thereafter, he joined in the post, Lordship.
Okay, we'll see.
Obliged,
Yes,
Lordship.
Yes,
See, for respond number 3, I have filed my wakalat number today.
notice was issued on 18/12.
Yes.
Okay.
Otherwise,
Pursuant to the-
Lordship,
And
that-
other, as well, you were making a mention this morning.
Yes, my lord.
Where is the office note?
My lord, 8/1/2026, my lord.
Otherwise, his
In
fair
compliance
price
with the order
license
of-
was restored, Lordship.
Retail license. License has been restored.
I need to instruction, my lord.
No, it's a written order.
Yes.
My lord, let the matter be listed after 2 days, my lord. In
No,
the
not required. We are recording his statement and this is an order.
Yes, my lord. I have just seen, my lord.
Ah,
I have no instruction.
okay. Heard.
What tree was there?
T-shirt.
Hi, Alam.
T-shirt.
Tisik, learned counsel for the petitioner, who by means of this application had alleged willful and deliberate disobedience of an order dated 18/9/2025 passed in WPC 735 of 2025. Full stop. By the aforesaid order, the suspension of the retail license was set aside and the same was directed to be made operational. Full stop, para. Notice in this petition was issued on 18/12/2025. And today, Sri S.R. Barua, Learned Counsel, has entered appearance on behalf of the respondent. Three. You are also appealing.
Yes, my lord. I'm for respondent number 1.
What is your name?
G. Anthony. My
G?
lord, G. Anthony on behalf of Dina.
Uh,
We will be filing a
Sri G,
wakalat number.
no, not required. Sri G. Anthony, Learned Counsel, appearing on instruction of Sri D. Nath, is present for respondent number 1. Para. Sri Barua, the Learned Counsel, has placed before this court that in compliance of the order passed by this court on 18/9/2025, an order dated 15/12/2025 has been issued, whereby the retail license of the petitioner has been restored. And the beneficiaries of the petitioner, of the beneficiary of the fair price shop of the petitioner, which was tagged with the fair price shop of Sri Alok Das, have been withdrawn. Full stop, para. In view of the aforesaid, Sri Sheikh, the Learned Counsel, has however submitted that he does not have any instructions in this regard. Para, be that as it may, in view of the order dated 15/12/2025 passed by the Co-District Commissioner, Lakhipur Co-District, comma. This court is of the opinion that there is no requirement of proceeding further in this contempt petition, as the order clearly appears to have been complied with. Para. Petition accordingly stands closed. Order dated 15/12/2025 is made part of the records. You have an extra copy?
Lordship, I am
You
having.
give a copy to Mr. Sekhos.
Lordship.
Highly obliged.
Yes, please, your Lordship. Lordship, this IA is for condonation of delay of 61 days. Lord, in preferring a
Eh,
restoration.
restoration?
application. Yes, my lord.
Notice was issued.
Notice issued, my lord, respondent number
Yes.
1 appeared.
Respondent number 1, I am appearing.
Who's one, madam?
Hridayananda Kupon.
No, who is he? The workman?
Yes,
Yes,
ma'am.
What do you say?
Lordship, we need 3 weeks time to file our objection. Uh, in- From 16/11/2015 to March 2019, the company has not paid the ADR amount, which is directed by this honorable court on 27th.
Your petition was against an award of the
Yes.
labor code.
He was terminated and he came before the labor court, my lord.
Labor code directed his
Yes.
reinstatement.
That award has been challenged in the writ petition.
Writ petition got dismissed
Dismissed
for
for
non-prosecution. And you are trying to get it restored.
Restored, my lord. My lord, what happened, my lord, we filed a restoration petition within 30 days, my lord. We earlier filed it on 17/9/2025. That was within 30 days. But, my lord, there is a lapse, my lord. We filed it as IA civil, my lord. It ought to have been
MC.
as a missed case, my lord.
Doesn't matter,
So, my lord-
we can have it as MC.
My lord, no, my lord. That was not registered, my lord. We tried to correct it, but we were said that it has to be filed as a missed case. We refiled it as a missed case. In the process, there was a 61 days delay, my lord.
Okay.
My lord, what I may humbly submit, my lord, that this 61 days delay may be condoned, my lord, and let the missed case be there, my lord, for restoration, my lord. But that the delay has totally
You
occurred
want
because of
to,
this.
you want to file your objection on the delay aspect. Let them file them.
Yes, sir.
But
Respondent number.
if what Mr. Sharma has submitted, if that is the correct position of facts, then we don't think we'll be very strict. There's no question of being strict with the delay aspect. There's no delay.
Yes, my lord, section 14 probably, my lord, if I'm correct, my lord, limitation act also covers, my lord.
No, that's not 14. 14 is pursuing in a court without jurisdiction.
Yes, there we
That
cannot
14 is
file it,
different. You have a good reason on facts. You presented as an IA civil. It should have been a missed case.
Yes, my lord.
Registry could have been. We could have rectified it. But nonetheless, yes, Mr. Datta,
Lordship, in this case, apart from that, Lordship, normally delay will to the court.
you can contest on the main part.
Main part, and but.
We can condone the delay.
Lordship, but in this case, Lordship, one pair I have made, the award was passed on 2015. Then, and this honorable court, by the order dated 27/3/19, has directed him, the management, to pay the existing salary to the.
Last page
petitioner.
is drawn,
Yes,
17B.
Lordship. From 2015 to March
See, Mr.
2019. They have not
If
paid.
you go on to those aspects,
Lordship.
it will amount to you want to contest on merits.
Yes, Lordship.
You can contest on merits. We can take up the 17B aspect also.
Lordship, that delay
Because
of.
the amount you consume in
Yes.
filing pleadings of objection,
Yes, yes.
that may not be to the benefit of your client.
Okay.
Your client wants an
Yes.
expeditious
Yes.
disposal,
Lordship.
isn't it?
So my prayer is that let delay be condoned subject to payment of that area amount of that.
That we cannot say today.
This is.
First, that has to come before us. That is not even before us. If we condone the delay,
Lordship,
restoration
constantly
petition.
during the
And restoration petition? What about the miscase?
Miscase copy I have not seen, only I receive only that.
MC 54?
Copy I may provide.
Copy I have not given, Lordship. I have received only that.
You can give a copy today.
Yes, my lord, given, my lord. I have extra copy.
See, the aspect which you are raising is a very
Lordship.
important aspect, but
Yes.
that has to be passed in the
Main case, Lordship.
main case.
Yes.
And you need to file an affidavit that 17B has not been complied with. Have you filed an affidavit?
I have filed affidavit.
You filed affidavit
File affidavit.
in the main writ petition?
Main petition.
Yes, Mr. Sharma, 17B.
They have.
My lord,
filed-
the thing
they have-
is that, my lord, in our earlier petition that has been dismissed, my lord, I was not there, my lord. So I'm not
See,
saying that, my lord.
see what we do, we condone the delay.
Lordship.
Yes, ma'am.
We keep the miscase open. We will
Yes.
not pass any order. And you, in the meantime, you take instructions on what steps have you taken for compliance of 17B.
Yes, sir, definitely. Sure.
We would not have directed you if no affidavit was filed. He has filed the affidavit that this is not gainfully employed and he's entitled to 17B.
And for past repeated 3 orders, Lordship. Despite 3 orders, Lordship, they have filed, they have paid some amount, but
Heard.
not all entire amount.
Sri Sharma, T.R. Sharma, learned counsel for the applicant, who by means of this application has prayed for condemnation of delay of 64 days,
61 days.
61 days in filing the connected miscase for restoration of WPC
2274 of 2020.
2274 of 2017. Full stop. Sri Sharma, the learned counsel, has submitted that the restoration application was indeed filed within the prescribed period of time, which however was done done as an IA. Full stop. The same was however not accepted by the filing section, and subsequently the miscase had to be filed, and in the process there has been a delay of 61 days. Full stop. Para. He submits that the delay is not at all intentional and there is no negligence. Para. Sri P.P. Dutta, learned counsel for the sole respondent, and for the respondent number 1,
31.
has submitted that he would not have serious objection in the aspect of condonation of delay under the facts and circumstances of the case. Para. In view of the above, the delay in filing MC 54 of 2025 connected to WPC 2274 of 2017 is condoned. Full stop. I stands allowed. Full stop. Let the miscase, let MC 54 2025 be listed on when?
25 February. 25 February.
25th February. Full stop. Since not 25th, 28th of February, 20.
Yes.
28th of February, 2025, 2026. Since the writ petition is pending since the year 2017, and this court has also been apprised that there is no compliance of Section 17B of the Industrial Disputes Act 1947.
Partly compliant, full compliant.
There is no full compliance. Sri Sharma, the learned counsel, is directed to obtain necessary instructions in this regard. Full stop. This court would also make an endeavor for an early disposal of the writ petition
Yes, sir.
after passing appropriate orders in the miscase.
28 February will be holiday.
20.
No.
Okay.
20.
20. Okay.
2020.
28.
No. Yes, madam. 28. I'm obliged.
28 is not open.
Yes.
And I thought 28.
7th and 21st, first and third. First and third. But it is 20.
Obliged.
Yes, next.
22.
You can order 22. Yes, Mr. Sarkar?
So notice is already served, parties is already appeared. Also, kindly see the last order.
Yeah, Mr. Islam for whom?
Malad, I am for respondent number 10, private respondent.
Affidavit filed.
Not Malad.
Filed
But
affidavit.
today Malad, I have filed the Wakalat number itself, Malad. I have gone through.
What is the matter?
Lordship, we are the settlement holders of 2 ghats, Lordship. During the lease period, Lordship, the respondent authority without issuing tender, Lordship, and newly created a ghat and settled the same to the private respondent.
It is within your operation area.
Yes, within the operation area. Lordship, respondent.
Your settlement is under what law?
Lordship, we have followed all the procedure 105 of the Panchayat Act. We have followed the.
You're also under the Panchayat,
Yes, Lordship.
not under the Ferries Act.
No. Panchayat.
My lord, having this, my humble submission, my lord, first of all.
You are running, Mr. Islam, you
Yes,
are
yes.
running.
Yes, I'm
You
running.
file your affidavit then.
My lord,
What is your tenure, Mr.
Just,
Sarkar?
my lord, one thing, my
One
lord,
second.
he has approached two
One
courts
second,
simultaneously.
what is your tenure?
Lordship, till the 36, 2000, this year.
36, 2026, and yours?
My lord, I am,
All set.
initially, I was given the experimental basis for 1 month. Subsequently, it was extended.
What were you saying? See, this is the second petition. What was it?
My lord, what had happened out of the same facts, the same petitioner first approached before the municipal court. The same case is fixed on tomorrow. And then file this writ petition
Parallelly?
parallelly, without mentioning a single whisper in the writ
We have
petition.
a writ
But
petition,
this
we have
writ petition may
mentioned.
be straightforward, dismissed with heavy cost.
Where have you
That
stated?
cannot be done, my lord.
Where have you stated in your petition?
Nowhere.
Mr. Sarkar, you cannot do this.
Lordship, yes, Lordship, we have mentioned. Lordship.
And I have got the notice.
He was not settled by.
It's
Only
temporary.
allowed to collect the toll and
Experimental.
on an experimental basis and to deposit in the department, not as a lessee man. The impugn order is saying itself.
Lordship, kindly see the
Only
impugn
to
order.
collect and
Lordship.
deposit.
How
in the-
can he approach in two courts simultaneously?
Lordship, we have
Very
mentioned in
serious
page
issue.
11, Lordship.
Page 11, let us
Page
see.
11, Lordship. In first para, last 4 lines, Lordship. First para. Page 11.
No,
In
you
this-
have mentioned.
In this regard, it is to be mentioned that.
235, is mentioned.
Page 11, Lordship.
Yes, we have said 235 or 25. Title suit,
Yes, Lord.
last line.
Lordship.
Which,
Is it the same case, Mr. Islam?
my lord, page?
Page 11,
11.
just above para number 8.
Eh,
Just above para number 8.
Yes, but same case, but without withdrawing the same ballot, issue is same, challenging the same order. The two case cannot be go simultaneously.
Lordship, we are instructed to withdraw the same, Lordship. But we have not yet withdrawn, Lordship, but it is.
During the pendency, cannot file ballot.
We have
You file your affidavit.
Yes, well,
Um,
I'll file.
Heard 380 Sarkar, learned counsel for the petitioners. Full stop. Para, in this case, notice was issued on 10/12/2025. Full stop. Para, Sri. As Datta, learned standing counsel PNRD has submitted that that there is no cause of action for filing this writ petition, as no settlement as such has been given with the private respondent, and only he has been authorized to collect the tolls and submit it to the department. Para. Sri Islam, the learned counsel, who has appeared for the respondent number
10 minutes.
10, has also raised, has strenuously raised an objection on the maintainability of the petition on the ground that the petition has been filed without any bona fide intention and by misusing the writ jurisdiction. Full stop. He has specifically submitted that on the same cause of action, a civil suit has been filed, and though a mention has been made, and though mention has been made in the writ proceeding, two parallel proceeding, there cannot be two parallel proceeding on the same cause of actions. Para. Sri Islam, the Learned Counsel, is given 3 weeks time to file affidavit of opposition.
1 week time may be granted, Lordship. Some few months are remains, Lordship.
Your bona fide is in serious doubt.
Yes, Lordship. That's so, Lordship. Kindly see the Lordship improved
3
order.
weeks. We'll give you a date list on. Today is what? 19th.
Today will 19 minutes.
We'll have it on 9th of
February.
9th, 20 days, not 3 weeks. 1 day less.
Yes.
9th.
Much of less.
Yes, next. Mr. Sayala?
My lord, that regarding the banning order, my lord, issued without so-called without hearing, my lord, nothing.
Page 91, my lord. That last occasion your lordship wanted
No clarity. No clarity on what ground.
no clarity.
Where is CGC? K. Gogoi?
CGC, my lord, he said that he has nothing to do with the industrial institute of technology, my lord. And we have served notice on him, my lord.
Who's the respondent, main respondent?
Main from National Institute of Technology, my lord.
Oh, we look for Mr. Chaudhary, SP Chaudhary.
Not here, my lord. So.
SP Chaudhary.
Yes, SP Chaudhary, no, my lord. Because without instruction, they cannot appear, my lord. My lord, and here various tenders are being explored, my lord. They are unable. Because the first order itself make it clear, my lord, 10, 12, last two paragraphs, 8 and 9. 7, 8, 9.
Heard. Yes, anybody is appearing? No. In spite, what does the notice say? Notice has been served.
Yes, my lord, yes. That was the service. That we have filed the affidavit also.
Heard. Sri G. N. Sahiwala, Learned Senior Counsel, assisted by Sri M. Sahiwala, who is aggrieved by an order dated 27/10/2025, whereby the petitioner has been banned for 2 years
Yes.
from participating in all tenders.
Yes.
Full stop. It is the case of the petitioner that no reasonable opportunity was given before passing such order. Correct? The Learned Senior Counsel has drawn the attention of this court to the order dated 10/12/2025 passed by this court while issuing notice and an observation was made that the interim prayer would be considered subsequently. He has also submitted that in terms of the direction passed by this court, the respondents have been served, and so far as the respondent numbers 2 and 3 are concerned, the service is also done through Dusty, and an affidavit has been filed on 29/12/2026 in this regard. Full stop. Para? When this matter had come up on 8/1/2026, this court, after taking into consideration the aforesaid facts, had given a further opportunity to the contesting respondents for appearing. And even today, the contesting respondents 2 and 3 have not appeared and contested. Para? Contested. Contested. Para na. In view of the above, this court is required to consider the prayer for interim orders. Para? The Learned Senior Counsel has submitted that there has been gross violation of the principles of natural justice while issuing the impugned order dated 27/10/2025. In this regard, he has placed reliance on the case of Erusian.
Yeah.
Erusian Chemicals.
That's Golkha Security, my lord.
No, not Gorkha. The first one, Gorkha comes later. The first one is Erusian Capital
Yes, sir,
Equipment.
yes.
75 or 83.
Yes.
Oh, what is it? Erusian Equipment and Chemicals. And the subsequent case of
Yes.
please give Erusian. And the subsequent case of Gorkha.
Golkha Security total 14/9 SCC 105. And nowadays, my lord, Supreme Court has further developed that hearing should be given. Erusian is 75 1 SCC
75.
770.
75 1 CC
70.
70 and Gorkha
Golkha is 14/9 SCC 105.
105. Please give the citation, Mr. Frank, in a separate page, okay? Considering the aforesaid comma, it is directed that till the till the next date fixed, comma, the impugned order dated 27/10/2025 shall not be given effect to. Would remain suspended. List this case on 16th of February 2026. Full stop. The interim order would, however, be reconsidered on the next date. Citation